case. I'm Yodit Tewolde. We begin tonight in Minneapolis, where the federal trial for the 3 former officers charged in George Floyd's killing is set to get underway. The jury was selected in less than a day. Most of the 18-member panel are white, with the exception of 2 Asian jurors, 10 women and 8 men. Former officers Tou Thao, Keung and Thomas Lane are facing federal charges accused of depriving Floyd of his constitutional rights for failing to act as Derek Chauvin kneeled on Floyd's neck for more than 9 minutes. Opening statements are set to begin on Monday. Here to weigh in on what we can expect next week are criminal defense attorneys Phillip and Brian Watkins. Great to have you both here. All right, so the presiding judge insisted that jury selection be done in 2 days, and the attorneys got it done in 1. It took 2 weeks for attorneys in the Derek Chauvin trial, though, to impanel a jury. But of course, we're talking about state court and different charges. But nevertheless, there's a huge difference in the timeline. And Brian, I'm always concerned about judges rushing a process like jury selection. Your thoughts on how quickly the jury was selected?
I disagree with the judge's ruling to put time limits on things like that. I mean, these are people's lives that we're dealing with here, and time, shouldn't really be a factor. I mean, of course, within reason, but jury selection never takes 1 day, especially on serious charges like this in a complicated case with multiple defendants. And so you have multiple lawyers questioning the jurors. So usually that extends the jury selection period of time. And so I don't know why he would put such time constraints on them. It just sets it up for an appeal later. So the judge should do it right. You should do it right the first time.
Phillip, do you agree? Should the judge have given the attorneys all the time that they need?
I mean, Brian hit the nail on the head. The extent that the judge wants to make this not an appellate-related issue, certainly to answer your question, should have given them more than 2 days or given them any time limits at all. Because of course the lawyers are always going to be exploring constitutional-related issues with the jurors. Can they be fair and impartial? Can they ultimately, decide on the facts and the law? To the extent that you don't have the ability to be able to question fully into those issues, as a judge, you do set the matter up to potentially come back to you on appeal. Nevertheless, you hit the nail also on the head, Yodi, when you just talked about the distinction between federal and state court. Look, in federal court, a lot of times there is not the, one-on-one attorney to, potential juror questioning that you have in state court that tends to go on a little bit longer. And so going into federal court, you do generally understand, short of certain judges, that voir dire, the questioning of the juries, may not actually go as long as in state court. But, wholly agree with Brian. You don't necessarily, as a judge, want to put a time constraint on this.
So, guys, this predominantly white jury is now seated, and the judge made an interesting statement during jury selection that I think is halfway true. He told a black prospective juror that race was a non-factor in the case. Now, sure, race has nothing to do with the crimes that the officers were charged with, but the facts in this case involve a black man accused of a minor crime and how these officers handle the situation. Brian, doesn't race have everything to do with how some police officers treat black people and how they choose to enforce minor crimes against people of color in general?
It does, but it's no place in the court of law. Legally speaking, race does not play an issue in the court of law, and the judge has to say what he had to say. But with the media coverage that this case got, like I said, we were just saying that the judge, I think, made a mistake in cutting voir dire so short, especially because of the media attention that this case got. I thought that the lawyers should have been able to dig deeper into the prospective jurors and what their bias is and what they've heard on the news and such. And situations like this, the judge is trying to sanitize the race issue. Of course, we all know that it exists, but legally speaking, it is not an element of the crime. It's not something that the juries are going to be deciding. The juries want to look at the facts and whether or not the facts meet the elements of the crime.
Phillip, your thoughts?
I think anytime I've ever been in a position where I'm questioning a jury, I mean, one of the things that, we start with as lawyers, as the finder of fact, which you as a potential juror, to the extent that you're chosen to be on the jury, are going to be. You don't want to leave your common sense and everyday just logistical understanding of the way that this world works outside. Let's just be frank. These jurors, if they have not been hiding under a rock for the course of the last 3 years, understand full well the thread that race has in terms of this case, what happened with Mr. Floyd. This was an internationally recognized event that has caused a lot of change, has caused a lot of questioning, and will just be a defining moment for the rest of our lives. So to the extent that the judge said that race plays no part, from a legal standpoint, of course, he has to say that to set the record straight. Justice, theoretically, ideally, and ultimately is blind. However, these jurors, when they come in, are not going to leave their everyday experiences outside. So will race not end up playing a part in this case? I don't believe so from the juror's perspective, but the judge has to cover the record.
All right, guys, let's move ahead to Monday's opening statements. Prosecutors, we know that they have a high bar in convincing this jury that these officers willfully deprived George Floyd of his constitutional rights. Opening statements is the first time that the lawyers get to address the jury and lay out essentially a roadmap for their case. So back to you, Phillip. What are you expecting from the prosecution's opening?
I anticipate it to be somewhat similar to what we saw in the state case, where there is going to be a period of time spent humanizing Mr. Floyd, reminding the jury that this man had a life, that this man had a life that was taken in an unjust and, at least with respect to the federal case, unconstitutional manner. To the extent that he ultimately is humanized, to the extent that Mr. Floyd is made to be not just a pivotal defining moment in this country, but a human being, right? They ultimately have to bring him back to life to explore the nature and circumstances of his unjust death. And if they do not do that, it would be close to legal malpractice. But what I will always generally say, when you're in federal court, when you're practicing at that level, these assistant U.S. attorneys, they understand both how to try a case on the law and the facts. There has been no loss of an understanding of what has happened here, the magnitude here, the media attention that's here. I expect the government to come in ready and prepared to both humanize Mr. Floyd, but also try their case at a high level.
Brian, there are three defendants here. Keung, that is, knelt on Floyd's back, Lane restrained his legs, and Thao prevented concerned citizens from helping. So what can we expect from defense attorneys in their opening?
The defense attorneys are going to absolutely separate their clients from Derek Chauvin. They are going to say, Derek Chauvin killed George Floyd, not my client. And that is going to be the hardest part for the prosecution, is to connect their actions to Derek Chauvin's actions. Derek Chauvin is the one, he was the leader. He was controlling the scene. He's the one that kept the knee on him. He was the one that, could have taken his knee off. And I think they are going to have a hard time making these officers' actions the same as Derek Chauvin's action. And the defense is going to be saying all day, Derek Chauvin did it, not my client.
Interesting point to raise that, because how do you think the guilty verdict in the state trial for Derek Chauvin and his plea in federal court is going to impact this case or this jury? Brian.
Oh, yeah. Well, it is going to impact it because Derek Chauvin, A, admitted that he did it, B, was found guilty of doing it. So we know that Derek Chauvin did it. Now, the question is were my clients, were the defendants, were they obligated to stop him? What were they supposed to do? And did they do it? They did not do it. Now, the question is going to be, are they obligated then to stop another officer from violating his rights? That's going to be a tough legal question that I don't think that a jury is going to be able to say, oh, yeah, it's their fault. They should have stopped him. I believe that when you look at the hierarchy in the police force, and he's the sergeant, and I didn't know to the extent of what he was doing, I think those are going to be great defenses to separate their actions from Derek Chauvin's actions.
Phillip, do you think that the defense is also going to point out that Derek Chauvin was more senior than the officers, the three here? Some may have been under training under Chauvin's supervision. Do you think that that's something that they may hone in on in their opening?
I don't even think it's a may. I think that they absolutely will. I would be very surprised if they didn't. To Brian's point, they essentially are going to want to be the prosecution's, co-attorney for, prosecuting him all over again, in regards to what happened in the state case. And as you noted, he just pled guilty not too long ago in regards to his federal civil rights charges. And so I think that they will ultimately very much so want to keep the attention pointed on him. Two of the defendants in particular, we know, have issues in regards to the fact that they as well did help to suppress Mr. Floyd from being able to get up. One of the officers had restrained his legs, the other had a knee on the back, while the other officer was essentially telling the bystanders to go away, and certainly none of them at any given point stopped Chauvin, whose actions in particular led to Mr. Floyd's death. So I think that they do have issues. I wouldn't be going into the trial feeling good. I do think, do they have more of a defense in some respects than Chauvin did? Yes. But I think that they are very nervous tonight and will be very much so this weekend as Monday approaches, and the fate potentially of the rest of their lives will be on trial.
All right, Phillip, Brian, you two sit tight. When we come back, my legal experts weigh in on another case out of Pennsylvania making headlines. More Making the Case after this. We have an update tonight on a case involving an officer-related shooting out of Pennsylvania, leaving an 8-year-old child dead and injuring 3 others. The 3 officers involved have been fired from the police department in Sharon Hill, which is about 13 miles southwest of Philadelphia. BNC's Astrid Martinez has the story.
And the 3 officers involved in this case were fired last night, just 2 days after the district attorney involved in this case charged them in connection with the death of 8-year-old Phonta Bility. The attorney for Phonta's family says they don't believe the officers acted out of malice, instead out of recklessness.
These officers made a split-second decision to return fire. We trust them to get that decision right, and they got it horribly wrong.
3 officers charged with the shooting that killed a child and injured 3 others outside of a Pennsylvania football game last August 27th are now out of a job.
6 ayes, 1 no.
The Sharon Hill Borough Council voted 6-1 to fire Devin Smith, Sean Dolan, and Brian Devaney after a grand jury recommended charges against the officers for killing 8-year-old Phonta Bility.
These 2 guys get in a gun battle, and as a result of that gun battle, a whole lot of bad things happen, including the killing of a little girl.
According to a criminal complaint, the 3 police officers were stationed opposite the stadium's exit. As fans were leaving, bullets rang out and a car turned onto a street directly in front of the officers. In response, the officers fired in the direction of the vehicle and the crowd. Attorney Bruce Castor represents Phonta's family.
Clearly here, nobody, not even the most ardent anti-police, think that the police officers here intended to kill Phonta Bility. Instead, they recklessly came to the conclusion that the people in that car were involved in some criminal activity.
Initially, the DA charged teens Angelo A.J. Ford and Haseen Strand with Phonta's murder. The teens still face other charges for their role in the events that day.
There was a lot of more legal discussion, a lot more research. The DA impaneled the grand jury, and now he's calling witnesses and learning stuff about the case that he didn't already know. So he recognizes that he's mischarged. He changes that, and he decides to charge in the direction that they did. I frankly think that the case is now going in the right direction.
The officers are charged with 1 count of voluntary manslaughter, 1 count of involuntary manslaughter, and 10 counts of reckless endangerment. In a statement, the attorneys representing the officers said the men are innocent and remain heartbroken for all. And according to a criminal complaint, one of the officers was not wearing a body cam that night. Now, body cam footage was recovered from 2 of the other officers, but it was not recording during the time of the 2 gunfire outbursts that happened that evening. In Sharon Hill, Astrid Martinez for BNC.
Let's bring back my legal panel, criminal defense attorneys Phillip Hamilton and Brian Watkins. Brian, officers charged and fired 5 months after this incident is an anomaly, right? This is why we take this as a win, but prosecutors still need to secure a conviction. Are the charges here of manslaughter appropriate?
It's going to be a tough case. The bottom line here is police do have a tough job. They do have to make split-second decisions, but one of the decisions they always have to make is you only take a shot when you have the shot. I mean, you have to have your target in range, you have to have your target in your sights, and you have to be able to hit your target, and you have to know that before you pull the trigger. And doing that, pulling the trigger without knowing that you could hit your target is a problem. Does it rise to the level of criminal liability? That's going to be the question. Normally in these types of cases, the other individuals who prompted the shooting would be charged with the 8-year-old's death because they were in the event of committing a felony and someone was killed. Normally, in situations where a person is committing a felony and the police come in and they shoot either the co-conspirator or even another person, they are charged with that murder for starting the gun battle, for setting the gun battle off. So this is a unique situation. I don't think that they're going to be able to make their case. I don't think it's going to rise to the level of criminal recklessness. Obviously, it's going to be civil liability here, and I think that's what it is, but I don't know if they're going to be able to make a criminal case out of this.
That's interesting. Phillip, what is your take? Do you think the prosecution has an uphill battle here?
I would actually have to disagree a bit in part. I think from a civil liability perspective, I think per se, we have liability here, and that was told in many respects by virtue of the fact that the city council voted to fire these officers. I think as regards the grand jury investigation, to Brian's point, actually, I believe initially the two gunmen that were getting into the altercation outside of the school that led to the shooting were initially, I believe, charged with felony murder. I think that those charges ultimately were taken away once the officers were charged with, voluntarily manslaughter for, their reckless actions in, let's just be frank, shooting at a car. I have not heard any details in terms of were the occupants of that vehicle in any way shooting at the officers. Were they driving toward the officers? The way you may remember in the Sean Bell incident in New York, those officers said that they thought that the car was, driving toward them, and so they shot for their own self-defense. I'm not really hearing a reason as to why the officers shot. So to the extent that they made a split-second decision, I need a little bit more information to understand what grounded that split-second decision. But if it's simply that they thought that occupants that had been involved in a crime were getting away and they just decided to shoot at the car, I think that even if the crowd wasn't there, they could potentially be brought up on charges of recklessness if, for instance, somebody within the car was killed, if they couldn't prove or in some way, make it clear that they were acting in self-defense. I haven't heard that. All I've heard is that they shot at a car, missed. They shot 24 times. This 8-year-old girl, unfortunately, ends up getting hit and dies, including some other people within the crowd. So I think in terms of uphill battle, I don't look at this case in that regard, other than the fact that the defendants are police officers. But I certainly think from a civil perspective, the city's already ready to pay. That's why they went ahead and fired those officers. From a criminal perspective, I think they have a pretty strong case.
Yeah, they also shot. There were shots from the officers that struck a car driven by two girls going to the football game that night that had no involvement. So I mean, they had no target, to Brian's point, and was just aimlessly shooting at just air. Brian, the former officers are set to be in court next Thursday for a preliminary hearing. Can you tell us what we can expect from that sort of hearing?
Well, at the preliminary hearing, we're not going to expect a lot from the defense. The defense is not going to put on a case. The defense is not going to put the defendants on the stand and let them explain why they did, what they were perceiving, whether they were doing this in defense of others, and all that type of thing. They are going to stay quiet. They're not going to show their cards, but they're going to sit and listen to the prosecution's case and see what their theory of the case is. The preliminary hearing, the standard's different than beyond a reasonable doubt, which is what the prosecution's going to have to prove at trial. At a preliminary hearing, the standard is just a preponderance of the evidence, which basically means, is there some evidence to suggest you did this? And clearly, there's some evidence to suggest that they did it. So the case will proceed to trial, but don't expect a lot of explanations from the defendants. Expect to hear the prosecution's case, but we'll have to wait to trial to see why the defendants did what they did.
Phillip, what kind of message is being sent to communities of color and law enforcement with these charges and this firing that just happened?
The firing, and it's so sad to say this, of course, but it's surprisingly positive. I don't know necessarily if it gives an optimistic outlook in terms of police reform moving forward generally, but I think in this very specific case, it was the right decision based upon what we know thus far. I think in terms of the charges, to the extent that we didn't have charges here where an 8-year-old innocent girl is killed essentially in a hail of gunfire when she had absolutely nothing to do with whatever had happened. And what had happened, again, did it actually justify the officer's actions in shooting into a crowd when you have to know that to the extent that you're missing, you could end up ultimately hitting someone or multiple people. So I think just commonsensically, he ultimately had to move forward on these charges. And if he hadn't, it would have been just cataclysmically the wrong decision. So does it ultimately, in this case, paint a broad stroke in terms of we can expect more optimistically to believe that, reform is coming in the way in which we would like to have it seen? I don't know, but I think in this very specific case, we needed to see the charges that have ultimately been brought.
Brian, I'll give you the last final word.
We don't forget, one of the officers was Black. And so it's a situation where these officers are, attempting to do the right thing. And, the question is, are we playing Monday morning quarterback? What if the individuals got in the car, fired out more shots and killed other people, other bystanders or whatever? People be like, hey, there was cops there. How come they didn't do anything? They saw those guys getting away in the car. They just let them get away. They didn't fire at them. So it's a tough position that the police are in. And it's a tough position to Monday morning quarterback the situation. Clearly, it seems reckless to me. Like I said, you do need to see your target. And obviously that was not the case here. But like I said, does that rise to the level of criminal recklessness? I don't know that it does. So I don't know what message it sends. Do we want cops to be less active in a shooting situation after a high school football game? Or do we want them to be more active? It's a tough situation. It's a tough call.
All right, Brian Watkins, Phillip Hampton, thank you so much to both of you for your time tonight.